Good morning, ladies and gentlemen. Today we are over here to discuss mainly the provisions of the Act of the Companies Act 2013, which is going to be effective after the constitution of the tribunals such as National Company Law Board Tribunal, which we have waited from a long time. So let's discuss the provisions and the procedures which are applicable from nowadays after the constitution or the tribunals. We will also discuss about the functionalities and how these sections going to affect. We will also discuss what these sections going to cater and what matter and what things they are going to cover on. So let's discuss the same. Section 7, subsection 7, except clause C and D, contain incorporation of companies in cases where the company has been incorporated by furnishing false or incorrect information. The tribunal has the power to pass order as it may deem fit. However, the power to remove the name and winding up of the company continues with the registrar of companies and high courts. So you have seen that if a person in India make a company or a foreigner make a company in India with a false or incorrect information, the tribunal have the power to pass the orders against the same. But winding up of the same and removing the name of the same from the registers of companies lies with the registrar of companies and high courts respectively. Apart from this, the other powers do not have significant changes or significant impact which is being given to the tribunal itself. So the whole section talks about the incorporation of companies matter pertaining to NCLT powers. Okay, now we move on to second section, which is section 14, subsection 1 and section 2, which says about alteration of articles. So the tribunal power which is being given over here, we will discuss it. Approval of the tribunal shall be sought for conversion of public to a private company. So if you convert a public company into a private company, then the same can only be done if you take the approval from NCLT. So now on, if you wish to convert your public limited company into a private limited company in India, then you have to take the approval through the tribunal for only the conversion matter. Okay, now we move on to another section, and that is section 55(3), issue and redemption of preference shares. In cases where the company is not in position to redeem or pay dividend on preference share, the company may issue fresh redeemable preference share with the approval of the tribunal. So the section 55(3) says that in the cases where company is not in the able position to pay, to redeem or pay dividend on preference share, the same company have to issue fresh redeemable preference share against those unpaid dividend or unredeemed dividend shares with the approval of the tribunal. So the issue of the new redeemable preference shares depend on the approval of the tribunal nowadays. So this is a significant change. So if you issued earlier the shares, redeemable preference shares, and you are not paying the dividend, now if you want to issue this the same lot or to the same people another set of redeemable preference share, then you have to take the approval of the tribunal. This is a very welcome step, I must say, from the NCLT itself, because the investor or the shareholder or the person who is having the share, the redeemable preference share, has the power right now. So this can only be done through tribunal. The tribunal can see if the whole lot is fraudulent or something like that, so they can also investigate into the same. So this is a very great thing we can say. Now if we move on to another section, 61(1)(b), it says power of limited company to alter its share capital. So it talks about limited company to alter its share capital consolidation or division of share capital, which results in the changes in voting percentage of shareholders shall be done only with the approval of. Now, this is a very specific or expertise power which is being given to the tribunal only, which says if you want to consolidate or divide the share capital, which result in changes in relation to the voting percentage of the shareholders of the same company, then for the same you have to take specific approval from NCLT. This is a very welcome note because mostly what was being done earlier is that people misuse the same consolidation or division of share capital. Now you need to have to divide or consolidate the same, you have to see what would be the impact of the same on the voting percentage of shareholders. If any impact is being sought over there, then you have to take specific approval of the tribunal. If tribunal, National Company Law Board Tribunal, does not give you the exact powers, then you cannot consolidate or divide the share capital which is affecting the voting percentage entirely. We can say that this is a very welcome note from the NCLT itself. Great powers, great privileges, nice one. If we talk about section 64.4.5 and 64.2.6, now if we cater, it's combined as a whole section 62.4, 62.5 and 62.6. For the issue of share capital, it mainly talks about if there any need arises for conversion of debentures issued or loan obtained from government by a company into shares and terms of such of conversion are not acceptable to the company, appeal can be made with the tribunal. So if their need arises that you have issued the debentures and need to convert those debentures or the loan obtained from the government itself by a company into shares and terms of such conversion are not acceptable to the company, then an appeal can be filed by company to the company law board tribunal. So this is a very welcome note, we can say. Nice one, and entirely a different approach we have seen from the NCLT. Now we will discuss section 71 subsection 9 to subsection 11, which talks about debentures. In cases where the company fails to redeem the debenture or pay interest on maturity, a petition may be filed with the tribunal. This is a very great scenario that National Company Law Board Tribunal is seeking the interests of the shareholders and the investors and the promoters and the other people as well these days. The whole section talks about if you want to issue the debenture, in cases where company fails to redeem the debenture or pay the interest on maturity, a petition against the same can be filed with the tribunal itself, and it can be filed by any aggravated person or any concerned person or a person who is deemed to be affected through the same. Now it provides a very great and broad image of the NCLT to the world. Section 75 talks about damages for fraud. So if we talk about the tribunal may grant extension of time to companies which fail to repay deposit and interest therein in terms of section 74.2. So if we talk about section 75 must be read with section 74.2. Damages for fraud. Tribunal can grant extension of time to companies which fail to repay the deposits and interest thereon only with the section 74.2 considering into the mind. So this is a grant extension time limit section, we can say. Now let's quickly get on to section 97, 98 and 99, which talks about power of tribunal to call annual general meeting and meeting of members. So the tribunal may on any application being filed by any person or member or director call for AGM or members meeting. The whole thing now gets purported Like if any person or a member or a director may call for an AGM or members meeting anytime by these sections itself. But the whole thing can be only done through with a legal ways, with a legal application which is being filed with the NCLT. Section 1194 talks about inspection of minutes books of general meetings. If any member is denied inspection or copies of minutes of book of general meeting, the tribunal has power to direct immediate inspection or direct the copies be provided to the member. It can be said that the same section provides a protective power to the person who is being denied by any of the reason or any of the excuse now have a huge power through the way of tribunal which can direct the same. Now, if you move on to section 130, reopening of accounts. For financial accounts of the company shall be reopened only by an order made by the tribunal. Financial account of the company holds very important powers in itself, can now be reopened only by an order made by the tribunal. So, if you want to reopen the financial accounts of the company which are last opened, can now be reopened only by way of an application being made to the tribunal only. Section 131 talks about voluntary revision of financial statement of board report. Approval of tribunal shall be sought for voluntary revision of financial statement and board report. So now if you want to voluntarily revise the financial statement and board report, you have to take an approval through NCLT. The procedure is now still in an array. It will come on a future aspect. We have to see what would be that. Section 140 second proviso to subsection 4 and subsection 5 talks about removal resignation of auditor not giving of special notice. So tribunal shall act on an application made for removal of auditor or suo motu pass orders for removal of auditor. It talks about mainly the removal and resignation of auditor and giving of special notice. Section 169.4, sorry about the section 169.4 corrected, removal of directors. Tribunal shall act on application made for removal of a director. So if a director is not removing or do not want to get removed, the same shall be done through the application to the tribunal itself. Section 213 investigation into company's affair in other cases talks about mainly tribunal may order investigation to the affairs of the company based on the application received from the concerned parties. The concerned party definition must be elaborated in the feature itself. Section 216.2 subsection 2 investigation of ownership of the company. Tribunal may direct investigation into membership and ownership of the company. Well, now the reasons of class action suits can be multiplied with these two words or with these two instances, mainly on the basis of the membership and ownership investigations. In the future, we will say we will have a unlimited way of class action suits which will be filed to tribunal only on the pertaining aspects of membership ownership on the basis of class action suits mainly. Section 218 protection of employees during investigation, change in terms of employment, discharge, suspension, removal of employees during the course investigation require prior approval of tribunal. Suppose if an investigation is being carried on in a company, you cannot remove a person from employment, discharge his suspension, remove the employees during the course of investigation. If you do so, you will be punished through NCLT. Or if we talk about the same into a different course of action, you have to get a prior approval of tribunal before doing the same. Section 221 talks about freezing of assets of company on inquiry and investigation, which mainly talks about tribunal may restrict transfer, removal or disposal of assets for a period not exceeding 3 years. So if your assets are freezed on inquiry and an investigation, the tribunal may restrict your company for transfer of shares, removal of shares or assets, or disposal of assets for a period not exceeding 3 years. The tribunal also got restricted only to 3 years time frame. That's pervasive action, we can say. Tribunal itself got restricted. So now we move on to section 222, which talks about imposition of restriction upon securities. The tribunal may impose restriction on transfer of securities for a period not exceeding 3 years. Here also 3 years imposing restrictions also laid. Section 224(5) talks about action to be taken in pursuance of inspector's report in case of fraud. The tribunal shall pass appropriate orders with regard to disgorgement of assets and also against the person found guilty. Okay, section 241, 242, except clause B of subsection 1, clause C, G of subsection 2, 243, 244, 245. Mainly, this is a huge section if we will talk about the earlier act of 397, 398 of the Companies Act 1956, Prevention of Mismanagement and Operation. Now, being relevant, hold it to 241, 242, 243, 244 and 245, which talks about tribunal shall pass necessary order in case of mismanagement operation. And now another part is being added over here, which is known as class action suits, which is being taken from US laws. Now specific class action suits may be filed or maybe orders may be passed through this section 241, 242, 243, 244 and 245. These section 5 sections are really important for the whole scenario of operation and mismanagement, must be carried or must be relevantly thoughted. For the same, the reference of word tribunal in subsection 2 of section 399, inspection, production, evidence of documents, blah blah blah, we will talk about later. Section 41, 415 to 433, both inclusive NCLT, NCLAT provisions related to constitution, functioning of benches, orders, appeals. NCLT and NCLAT orders have been dealt with these sections. So totally the constitution, functioning, branch orders, appeals related to NCLT, NCLAT orders totally depend from 15 to 433, both inclusive section related to NCLT and NCLAT. 434 talks about transfer of certain proceedings, mainly all matters proceeding or cases pending before the Company Law Board initiated under Companies Act 1956 shall stand transferred to a tribunal through this section 434 1A, B and 2. So now if your case which is being pending on the basis of Company Law Board 1956 Companies Act can now be shifted to tribunal itself considering the section 434 1A, B and 2. Appeals against the order of the Company Law Board passed before the constitution of the NCLT would continue to be before relevant High Court. So if a matter is being pending, suppose with the help of an example I am telling you, if an order of the Company Law Board passed before the constitution of the NCLT would continue to be made respective to the old laws, which is relevant, where the relevant authority was High Court. So this is an exception to the whole above section, which says appeals against the order of the Company Law Board before passing the constitution of NCLT would continue to be made before relevant High Court. So now we will be cleared by these examples. Section 441, compounding of certain offences. The tribunal shall compound offences where penalty imposed exceeds rupees 5 lakh or more, and cases where maximum amount of penalty imposed does not exceed 5 lakh shall be dealt with the regional director or such other officer authorized by the central government. So this whole section talks about compounding of certain offences. The tribunal shall compound offences where penalty imposed exceeds 5 lakh or more, and cases where maximum amount of penalty imposed does not exceed 5 lakh shall be dealt with by regional directors, such other officer authorized by the central government. So the tribunal can only compound the offences where penalty imposed exceed 5 lakh or more, where out above 5 lakh, if the penalty is imposed, then same will be dealt through RD or central government nominee authorized officer. So up to exceeds of 5 lakhs, tribunal itself, or more, and cases where maximum amount does not exceed 5 lakh. Let me come again. Tribunal shall compound offences where penalty imposed exceed 5 lakh or more, and cases where maximum penalty does not exceed 5 lakh. So let me clear the things. If your penalty is above 5 lakh or a level of 5 lakh, then it will be dealt through tribunal. If it's below 5 lakh, then it will be dealt through regional director and authorized nominee officer of the central government. Now if we talk about the resolution, section 466, which talks about resolution of company law board and constitutional provision, the same will be dealt through this section only. So this is my own perception, these related sections which I have made through this video journey. Sounds interesting to me. For the first time I have recorded my NCLT series section 1 demo part, web conferencing. I am CS Gaurav Kumar Sharma. My website is www.csgauravsharma.com. It is not an advertisement itself. I'm telling about my intro. I'm a company secretary based in Delhi NCR and practice over there. So if you have any query related to NCLT, you can call me on 9990-694-230, or you can add me on WhatsApp itself on the same number, or you can provide me your query over the mail. My email ID is gauravdelhi@gmail.com. Thank you for listening the whole series. Remain connected, guys. Very welcome move from the tribunal, and we welcome the tribunal on the latest update. We will talk you and carry you forward with the latest laws. Thank you very much, guys. Remain connected. Thank you.